Hi guys, Dan here. Today in this video, we're going to talk about the probate process in Missouri and specifically figuring out what property is even subject to probate. That's the first thing we got to figure out in any probate administration or potential probate administration. So the first thing to understand is that there are two different kinds of property. You have probate property and non-probate property. So when I call something non-probate property, what I'm saying is that it's passing outside the probate system. We don't need to worry about it. Okay. So generally speaking, when does property pass outside the probate system? Well, there are two main ways. It can either pass by contract or it can pass by operation of law. And when I'm talking about property that passes by contract, I'm talking about property that passes because of some contract that controls the management and operation of the asset. So as an example, checking and savings accounts, brokerage accounts, 401k IRA plans, all of these have detailed terms of service that are compliant with federal IRS regulations to determine how they have to be operated, and banking regulations. And basically, they allow you to set a designated beneficiary, a transfer on death, or a beneficiary, or a payable on death. Or in the case of life insurance, is another example. You can set a beneficiary on life insurance. So these are assets that transfer because of some designation that you have made pursuant to a contract, right? So the other category of property that will pass outside of probate, and before I move to that, one other category of asset that you could consider as passing by contract is property held in trust. Because technically, a trust is a contractual relationship. Anything held inside of a trust in most cases is not going to need to go through probate. But the other category of property that does not need to go through probate is property that passes by operation of law. So property that is in most cases held as joint tenants with a right of survivorship. So you can co-own property in three ways in the state of Missouri. You can co-own it as tenancy in common, as a tenant in common with another owner. And this is the default form of ownership for real estate in the state of Missouri, and is particularly whenever you are not married to the other co-owner. And in a tenancy in common, you own an undivided interest in your share of the property. Okay, so if suppose there are three people who are not married who own a piece of real estate together, they each by default have a 1/3 interest, unless otherwise specified. They each have a 1/3 interest in the real estate. And if one of them were to die, that interest would not pass to the other owners. It would not pass to their heirs automatically. Instead, their interest in that tenancy in common property would pass to their probate estate to then be distributed to their heirs or to the beneficiaries under their will. Now, the other form of co-ownership is joint tenancy with the right of survivorship. And in this form of tenancy, all co-owners own the whole property. So if one of them dies, that interest of the deceased person automatically and instantly passes to the other co-owners of the property. Essentially, their interest drops out and disappears. It does not fall to their probate estate. It does not pass to their heirs. Now, it's important to understand that this is not the default form of co-ownership for real estate in the state of Missouri. If you want real estate to be transferred that way, to be held that way, you have to specify on the deed, this is to be held as joint tenants and not as tenants in common. It doesn't have to be that exact language, but you want it to be something very, very specific, that you are not trying to create a tenancy in common. Now, interestingly, joint tenancy with a right of survivorship is the default form of ownership in Missouri and in many states for other kinds of assets like bank accounts, brokerage accounts, cars. These are the assets that people are, in many cases, a lot more familiar with co-ownership rules. In a joint tenancy situation, let's say you're on there with your mom and your mom passes away. If she dies, that account is now yours. You can take her name off, pull the money out, close it out. You don't have to go to probate. Okay. The third form of co-ownership is called tenancy by the entirety. And this is very, very similar to joint tenancy with right of survivorship. Essentially, it's exactly the same, except for two things. It only applies between married couples. So when married couples buy property together, the default form of ownership is tenancy by the entirety. So you automatically get that survivorship right when married couples buy real estate together. In fact, in Missouri, it also applies to any other kind of property that is co-owned or owned or opened jointly between spouses. And the other distinguishing feature of a tenancy by the entirety is that it provides asset protection as to the debts and creditors of any one spouse. So if one spouse were to get sued and the creditor were to try to collect on that debt against the tenancy by the entirety property by having it sold, they can't do that unless the judgment is against both spouses. Okay, so that's the key thing to understand, is trying to figure out when is property subject to probate. So with those rules in mind, the result is that property is subject to probate only if it is left in the name of the deceased person and it does not pass by contract or by operation of law. Make sense? So that's it for today. Let me know if you have any other questions. Hopefully that was helpful. Thanks.